Contesting a will is basically when the will is not valid. So somebody's made a will and it's not in accordance with their wishes, or it hasn't been done properly, and you then can challenge the will, and then you look at whether there's a previous will that is valid. So when you contest a will, what you're essentially saying is the person who's died, their estate is not to be distributed in accordance with that will. You have to look at a previous will or look at what we call the rules of intestacy, if there aren't any wills there. It's a case of corresponding initially with the other side and finding out whether they agree with you or not, and if they don't agree with you, then you may have to issue court proceedings. There are several grounds for contesting a will. The first ground is whether the person who's died actually had capacity at the time of making the will. Second ground is what we call knowledge and approval. So did the person appreciate what they were doing when they signed the will? Third ground is in relation to what we call undue influence. So did the person making the will, have they been coerced in any way into making the will against their wishes? Fourth ground is if the will has been executed fraudulently, so if somebody has faked somebody's signature. The fifth ground in relation to challenging a will is whether it's been executed correctly, so whether the correct people have witnessed it and whether it's been drafted in accordance with somebody's wishes. You can also challenge the distribution of an estate in accordance with the inheritance provision for Family Independence Act 1975, we call it the Inheritance Act, as to whether somebody's been left reasonable financial provision. Family members can contest a will, what we call disappointed beneficiaries. So if somebody has been left something from the deceased estate in a previous will and they've been cut out of the last will for any reason in accordance with the points that I've raised, they can look at challenging it. And if you're looking for reasonable financial provision, that can be family members, cohabitees, anybody who's been maintained by the deceased over a period of time. If you're going to contest a will in accordance with the Inheritance Act, you have 6 months from the date of the grant of probate. In relation to any other ground for contesting a will, there aren't really any limitation points, save for it's better to do it sooner rather than later, because if the estate gets distributed, as you can't get blood out of a stone, if somebody's distributed the monies, you can't backtrack from that. If you're contesting contesting a will on the grounds of capacity, it's as at the time the will was made. You need to look as to whether that person did or didn't have capacity to make the will. Now we're coming across more and more cases and really looking in relation to capacity. It's when people are suffering from dementia. So on a daily basis, their capacity may fluctuate, and over time it may go down like that. And it's got to be at the time that the will was made. Now that really is for a doctor to assess. However, if a doctor hasn't assessed somebody at the time of the will, you can get an expert after the event, and we can certainly look at that, to look at all of the medical records, to take into account the evidence of the family members and the like, and retrospectively go back and confirm whether somebody did or didn't have capacity.